Welcome to Private Lending Insights. I'm your host, Rocky Butani. In this episode, I interviewed Melissa Martorella, partner and attorney at Fortra Law. The topic of this interview is wholesale capital structures, including wholesale brokering, white labeling, table funding, and correspondent lending. I asked Melissa to explain each of them and also talk about licensing requirements, loan documents, and other legal considerations. This topic is mainly relevant to brokers, lenders, and capital providers, but it could be good information for real estate investors who just have an interest in knowing how capital structures work within private lending. I hope you find this episode to be insightful. Here's my interview with Melissa Martorella. All right, Melissa, thanks for joining me for this episode of Private Lending Insights. How's everything at Fortra Law?
Hey, Rocky. Thanks for having me. Everything's going really well, staying busy. Always a fun new day here with random questions and projects. So it's a good time.
Mm-hmm, definitely. And we're both gearing up to attend APL next week, the biggest conference in our industry. I assume you guys are going to be speaking on stage or you personally, as you always do.
I will be. I have a class on Monday morning. I'll be teaching one of the CPLA courses for new lenders, so that'll be fun. And then on Tuesday, on the main day, I also have a panel in the afternoon, so that'll be a lot of fun too.
Nice. All right. Well, I know you're busy. Thanks for taking some time for this. So I wanted to talk to you about different wholesale structures in private lending and have you explain to our listeners and viewers some of the specifics of the different types of wholesale and capital that originators can use to leverage other lenders and mainly for bridge loans. It could be for some DSCR loans, but we're mainly talking about short-term bridge loans. Okay. So with that, why don't we start with a basic wholesale lending, or what let's say the terminology here can be different for different people, but let's just take wholesale as a general term. Tell us a little bit more about it, how it's structured, how it works.
Absolutely. And I'm very excited to talk on this topic because I think it's an area where oftentimes we use the same term to mean different things. And it's one of those things, I'll get on calls with people and, they'll say, oh, I'm doing this, but then you have to confirm. So very excited to go over this topic. But yeah, so to kick it off, wholesale lending, really what that means, it's to me just any other, broker situation where you have an originator coming, they have a deal, but they don't intend to fund that deal themselves. And instead they know a lender who will fund that deal and they're arranging that loan transaction. They're putting those parties together. That's really all wholesale lending is. It's, what we think of when you think of a loan and the different parties there. But the big picture is you have a loan originator who's really acting like a broker who's putting the parties together. And there's going to be a separate lender that funds the loan to the borrower.
Okay, and let's talk about licensing requirements because there's some states that require licensing and others that don't. How does the licensing work in terms of what the originator is required to have and what the lender is required to have?
Absolutely. So really what you have to look for in this case, and obviously, or maybe it's not obvious, I'm just talking about business purpose loans. I know nothing about consumer loans. If you want to talk about those, I have a great referral for you. But just for everybody here, you have to look at two different things, and you have to look to the state where the property is located that's securing that loan. So this also assumes that this is a real estate secured transaction. But you go to the state where the property is located and you ask the question first, does somebody who is lending money in the state secured by real estate, do they need to be licensed? And if the answer is yes, then that lender would need to be licensed. And then the second question you have to ask is that originator, that broker essentially who's arranging the parties, does that action also require a license in that state? And then there might be situations where, maybe the broker is required to be licensed, but the lender isn't, or maybe both parties are required to be licensed. But, for example, here in California, if there's a licensed broker on a transaction, then the lender actually doesn't need to be licensed. So there's all sorts of exceptions to the rules, depending on the type of loans you're making, depending on the collateral, the loan size, all of those sorts of things. So it seems sometimes like it could be an easy question to answer, but it ends up being a little bit more involved, and that's where we come in to walk everybody through that.
Sure, but let's just cover some other states where this issue comes up. It's mostly in the West. I know there's some exceptions, but could you just quickly run through a list of a few states that people need to watch out for in terms of licensing?
Absolutely. Obviously, California, Arizona, generally you would need a license. There are some interesting exceptions there, though, depending on, like I said, collateral and loan size. Nevada's pretty strict, so that one's difficult. And like you said, a lot of the West Coast states generally will require a license of some sort, either for the lender and or the broker. As you go further east in the country, it's less so, but there are still some odd rules here and there. We were just talking about one today in Georgia, where you only need a license if the borrower is an individual and it's an owner-occupied business purpose loan. So very random, but it's something that you would need to know. But I will say that for most of what people are considering, as a general rule, the further west you go, the more you have to worry about licensing, and the East Coast is a little bit easier.
I've heard about some licensing requirements in New York and New Jersey. Is that a thing in business purpose lending?
So for both of those, our understanding and our research tells us that you need a license to broker in those states. So in this traditional wholesale lending situation, that broker, that party arranging the loan between the borrower and the person funding, would need to be licensed. I know there's other research and opinions that are out there, but just based on a read of the law, that's our understanding.
And do each of those states have a different licensing board or regime, or do they use the NMLS?
They usually have their own different board that will decide, you need this in California, you need this in Arizona, you need this in New Jersey, or whatever it is. So I get that question asked a lot, I'm a DRE broker in California. I can just use my broker license in Arizona, and you can't. Arizona doesn't care that your broker license is in California. They want you licensed there. They might use something like the NMLS. That might be a better question for my partner, Jen, who gets people licensed and maintains those licenses. As far as, oftentimes you can go to the NMLS website to see and track and get licenses updated and that sort of thing. So it's a helpful way of understanding where people are licensed nationwide. But otherwise, each state is going to have its own, I guess, like governing body or regulations related to licensing.
Okay. And in a state like California and Arizona, Nevada, these are a few states that come to mind that where if you're arranging the loan, you have to have a license as a broker, but then the investor or your capital source does not need to be licensed. Let's just say it's a DRE license. It's just a broker. They're trying to arrange a loan, and they find an investor, whether that's an individual high net worth investor or another lender across the country. It could be, let's just say, a lender based in New York. In those situations, the broker is still considered the broker. They're not really putting themselves out there as a lender, right?
Right, exactly. They're still acting as a broker. And so in California, at least from a licensing perspective, whoever that investor is, whether it's somebody in California or New York, they don't need to be licensed, because there's an exemption to licensing for lenders where if the loan is arranged by a licensed California broker, then that lender doesn't need to be licensed. There are separate securities issues, which again, Jen or Kevin, my other partner, would be able to answer, as far as when you have investors in other states, and making sure that that's compliant from just an SEC perspective. But from a licensing perspective and actually making the loan, then you would be okay.
Okay. And on a national basis, when we're just talking about wholesale lending, a broker brokers a loan to a direct lender, what are the potential liabilities for the broker in case something goes wrong with the loan? Does that vary based on the specific arrangement between the two parties, or is there something standardized as far as whether the broker originator has any liability in case anything comes up with the loan?
Yeah, another wonderful question. So first, what I'll say is if the state is deciding that you need a license to be a broker, so like California, for example, then they have their own requirements for that broker, their disclosure requirements, reporting requirements, things like that. There's a higher fiduciary duty between the broker and the borrower and the broker and the lender. So there's a lot more liability there. For states where a broker does not need to be licensed to perform that activity, I would say that risk is somewhat less, right? Because they're not a licensed party. It's just me out there being like, hey, Rocky, I've got a deal. You want to fund it? So, I mean, there could be some sort of liability if I've misrepresented things to you, general business practices and things like that. However, big picture in those situations, the way that I would have it govern is a separate arrangement or separate broker agreement. So if I'm a broker, even in California, and you're a lender that I work with a lot, I might have a broker agreement in place with you that talks about, what kind of fees do I get paid and when, what can you rely on about the deals that I'm bringing to you, and what can you trust? What are the sort of things that I'm doing for due diligence when I'm presenting you a deal, and that sort of thing. And then as far as that will somewhat limit broker liability, because if you're saying that I didn't do something that broker agreement you said I didn't have to do, that limits there. But then it also, you as the lender, gives you some recourse as well, because if I've told you that I'm going to run credit and all of this, and then I make misrepresentations about that, or I don't, then you can hold me liable under that agreement, even if it's a state where licensing is not an issue.
If let's just say it's in the state of Texas or in Florida where you typically don't have broker licensing requirements for business purpose loans, do you typically see the wholesale lender, if they are calling themselves a wholesale lender, do you typically see in their agreements or their loan docs where they say anything like, if the loan defaults, then the broker has some liability or has to pay back the commission? Do you ever see anything like that?
You could certainly do something like that. I wouldn't see it in the loan documents necessarily, because that's really the contract between the lender and the borrower. But you could absolutely put something like that in the broker agreement between that broker and that wholesale lender, just to talk about, or maybe I say, if that loan defaults or whatever, I'll take it back, I'll purchase it from you, or something like that. So they could have terms like that in there. I don't know how friendly they would be, or how often it would happen, but you could definitely have an agreement like that.
Yeah, and I don't see that being a common, occurrence, because there's a bunch of wholesale companies out there. I would imagine. I mean, if I was in the broker's shoes, I would not agree to anything like that. If it's just simply a brokered transaction, there's definitely other lenders out there that probably wouldn't require that.
Absolutely.
Let's talk a little bit about white label. There's some wholesale lenders out there that offer the wholesale uh, lending program with a white label option, and it seems like a lot of brokers like that. Tell us a little bit more about white labeling and how that works.
First, what I'll say is white labeling is basically identical to wholesaling, where you have a loan originator who's really brokering a deal to a third party. Except what's happening is that loan originator is representing that they are actually funding the deal. And so through that, you'll have a generic sounding lending entity that's the lender on the loan documents, like Funding Lender LLC or something like that. And so if I'm the loan originator, I can be like, hey, borrower, yeah, Funding Lender LLC is just my funding entity. That's what I put on the loan documents. But actually, it's you, Rocky, and I've just brokered this deal to you. At its core, that's what it is where you're hiding the identity of the true funding source to the borrower. So, but otherwise, everything else is the same. So I'm still brokering a loan to another party, and it's exactly the same as wholesale lending.
And in those cases, do you see where the lenders typically, in terms of servicing, they're using their real company name, or do they continue to use that generic LLC funding lender, whatever it is?
I usually, in these cases, a lot of times people will use third-party loan servicers or something like that, to deal with the loan servicing, or even after the fact. I mean, I know even for my own home mortgage for my house, servicers change every single day. So I don't think it's that uncommon for them after the loan closing to swap a servicer. But usually what I see in these situations is they either have their separate servicing arm that's named as a loan servicer in the documents, or they're using a larger loan servicing company who's just handling that for them.
Okay, so white label is just hiding who the real lender is.
Right.
Um, but are there any legal considerations? I mean, is white labeling allowed in all states?
Generally, yes, allowed in all states. No, the same licensing considerations would apply as with wholesale, because you have me brokering and I have you lending. We're just pretending that you're me. So you want to make sure that I'm not misrepresenting you. So maybe in that arrangement, in that agreement that we have in place together, maybe there's something about the things that I can say to borrowers or do or not do just to protect your reputation. And similarly, the benefit for me for doing this is not only do I, get to market myself out there as having the capital source to fund these loans, but also I'm maintaining those relationships with the borrowers too, because they're thinking that I funded this loan and everything. And so I can usually be more front facing with the borrowers down the line if they need a refinance, if they need a new loan, anything like that.
Okay, makes sense. Now let's switch over to table funding. This is an interesting one, and there could be white labeling with table funding, but aside from that, just tell us a little bit about table funding.
Yes. So in table funding, this one's interesting. And as far as I know, California is the only state that actually doesn't allow this. But table funding is like white labeling in the sense that I'm that loan originator, I'm that broker, and I'm trying to represent to everybody that I have the capital to make this loan, to the point where instead of using that generic LLC name that's actually you, Rocky, as the lender, I'm actually naming myself as the lender in the loan documents. So Melissa is the lender, and I'm saying, yep, I'm funding this loan. Except what's happening is actually at the funding table is you, Rocky, are the real lender, and you're funding the loan, and you're funding the escrow or the title. And I am simultaneously with getting those loan documents signed by the borrower, I'm assigning the loan over to you. And so there's a little bit more involved on that, because now the licensing scheme changes a little bit. Now instead of me needing to know whether I need a license as a broker, now I'm representing that I'm a direct lender. Now I have to, maybe a certain state didn't require a broker to be licensed, but it requires a lender. So now I have to make sure I have the right license in place. Some states require you to be licensed to sell a loan or use a broker to sell a loan. So have I dealt with that transaction properly? And in a few states, it requires a license to purchase the loan. So you'd have to make sure you have the right license in place to even purchase that loan after the fact, because that's really what that assignment is that I think people don't think about is, yeah, you're table funding, but ultimately is you're purchasing the loan from me, if we're being very technical about it. So we have to think about the different licensing that's in play and the activities that each party in the transaction is taking. And like I said, California does prohibit this. So you have to look at that as well.
So in table funding, when you say the loan gets assigned, this is really in closing, right? So it's
Mhm.
the originator, the broker, they're not putting up their own capital. It's just the funds are coming in from the investor or wholesale company or the table funder, whatever term you want to use. But does it matter to the borrower, or does the borrower know that this is happening?
They usually, again, similar to white labeling, they similarly won't know that it's you up until that moment, even, or even after the fact, they might not know. Again, my loan's been assigned a million times. Who do I care at the end of the day? No. But so there is that, like, that borrower might not actually know that you're ultimately going to be the lender on this thing until they get some servicing disclosure or notification down the line.
Okay, so California is the only state that doesn't allow this, and what's the reasoning behind that? What's so bad about table funding for California?
I think for California, a lot of this has to do with protecting consumers, even if it's a business purpose loan. Excuse me. So I think a big part of that is they want the parties involved to be honest about what they're doing. The other thing too is the broker license in California and the lender license in California are also governed by two different regulating bodies. So I'm sure there is some sort of conflict between the two as well. But I think mostly, and again, I don't know, this is me spitballing, but I think a lot of it is protecting the consumer, protecting the ultimate borrower, to know who's actually in on their transaction.
Makes sense. So it's just full transparency that hey, we need everyone in the transaction to know where the money's really coming from.
Right.
Okay. And let's talk a little bit more about the assignment of the loan. So assigning the loan is there extra work that goes into this? Is this something that the brokers need to pay extra for, or is it kind of a seamless process when you're closing a loan?
Yeah, I mean, it's another document so it's really, you should have both an assignment and an allonge to the note. But the assignment is the really super important one. It's the assignment of the mortgage or deed of trust, and it has to be recorded, which also means it must be notarized. So there's some additional costs just right there between recording and notary, that broker who's pretending they're the lender, they have to sign that and get it notarized, and you pay for the recording fees and that whole thing. Usually a lot of those costs are passed through to the borrower when these are happening at the closing table, though. Otherwise, for example, when we're preparing a set of documents and we're closing a loan that we know is being table funded, this is often just baked into the whole collateral package that we're preparing. So we'll send the loan documents to be signed, and then we also say, hey, broker, or, hey, lender, here's the assignment over to Rocky, make sure you get this executed and sent into the closing table so that when they record that mortgage or deed of trust, they can record that assignment right after.
And the loan docs, like you said, have the originator's name on it,
Mm-hmm.
not the assigned party.
Mm-hmm.
But have you ever come across situations where the company that the loan's going to be assigned to says, "Hey, I don't like your loan docs," or "I need something different in these docs"? Is that generally worked out in advance before the loan's even originated?
Yeah, I would say it's usually worked out in advance, and it's something where, there are also not, I mean, there's a lot of people doing this, but there's not like so many people. So we have worked with a lot of them too. So if, chances are I've worked with that lender, and I know, oh, they always want this prepayment penalty, or they want extension language that looks like this. So it's something that we're very familiar with over on our side to say, oh, it's so and so is the table funder, got it. Make sure we use the doc set that has their standard revisions in mind. But if it were a new one as well, that's the process that we would go through too, is say, hey, it's nice to meet you. Here's our standard doc set. What do you like to see? Any changes do we need to make, so that when these loans are closing, that the documents are in the place that they should be.
One final thing about table funding is, is this kind of a common practice in most states, and are brokers using table funding with large institutional lenders, or is it generally with smaller individual high net worth investors or family offices?
I mean, I suppose you could do it with both. We usually see it with much larger groups that are acting as that table funding lender, just because they have the resources to be able to handle the volume of loans in that capacity, and the servicing and tracking the assignments and all of that. That's not to say that you and I couldn't go do this, just not in California. But we could do this, and that's fine. But usually what I'm seeing is it's larger institutions that are acting in that capacity, usually.
And what about potential liability for the originator if they've brokered the loan, or not brokered, if they've originated the loan and it's assigned, even though their name was on the loan docs, when it gets assigned, are they releasing their liability from the deal?
That's another great question. I mean, so generally what will happen, and you should absolutely have this in place, is if you are a table funder like that, you'll definitely want to make sure that there's some agreement in place between that original self. It outlines what happens. Well, I was named as the lender for, 30 seconds before I sent it over to you or signed it over to you. And now I'm being sued in a chain of title thing or something. Like, is there an indemnity clause or whatever is going on? And similarly, if I've actually misrepresented a horrible loan to you that you ended up funding, what does that recourse look like? So you can definitely have that in place in that sort of third party agreement. The other thing that I'll say as well is when you're getting these assignments, especially from a title perspective, this is why I like to make sure that it does happen right away at closing. Sometimes these assignments will delay over to that ultimate lender who's funding the loan. And the problem that I have with that is you want to make sure all of the insurance around you, both title insurance and property insurance, liability insurance, are actually naming you the ultimate lender on those documents, or you're getting endorsements to those insurance policies to make sure that you are also covered as well. So it's just, there's a lot that kind of goes on in these. So you usually have a third party, like a law firm, processing a lot of these loans to close them because they're getting all of that information and making sure it's all organized prior to the loan funding.
And what if there's a case where the originator has a table funder lined up, all the docs and insurance, and like you said, names that table funder,
Mm-hmm.
and then it changes midway. You just have to redo everything to get it to a different capital source.
Exactly. So new assignments, all of that. Sometimes new underwrite, sometimes new docs if they like a different set of documents. So, yeah. Hopefully that doesn't happen too often, though.
Okay. And if someone's using a table funding arrangement, do they typically need to have a little bit more legal servicing, or not servicing? That's not the right word. Do they typically have to have an attorney involved in the deal versus using an automated loan doc software?
Absolutely. I think you can definitely go both ways. Some people, especially when they have strong closing coordinators and that sort of thing in-house, so those larger institutions, it makes sense that you're using an automated platform. But I do think for a lot of reasons, especially where you have all of these moving parts, you have, hidden parties and that whole thing, I think it's oftentimes helpful to have a law firm as an intermediary, helping to make sure that the loan closes correctly and on time.
Okay. All right. Sounds good. All right. That's all I had for table funding.
Awesome.
Why don't we take a quick break and we'll be right back. Support for this show comes from Forecasa, an amazing data platform for private lending and real estate investing. Private lenders, note buyers, capital providers, real estate investors use Forecasa in a variety of different ways. You can see which lenders have funded which loans. You could see which real estate investors have gotten funding or sold a property or purchase a property. You can see loan assignments to know where the loan was sold to after funding. Many people use Forecasa as a prospecting tool. I personally use it to vet lenders and for general market insights. It's become an essential part of our business, and I just wish I had access to it sooner. We publish some of Forecasa's data on privatelenderlink.com. When you do a search for lenders, you could see the top 20 lenders in each market, and we've also added the top real estate investors in each state and for some of the metro areas. Visit Forecasa.com to schedule a demo, and please mention that you heard about them from LenderLink and the Private Lending Insights podcast. And we're back with Melissa Martorella, and now we're going to talk about correspondent lending. This one has some complexities just because I've seen a bunch of lenders use the term correspondent when it may not be correspondent in the technical term. So why don't you explain correspondent lending to us?
Absolutely. So we were talking a little bit before about table funding. What I'll say in this case is, in table funding, I was that originator. I was putting myself as a lender on the loan documents, but I didn't have any money. Rocky had the money. So, Rocky's funding that loan. In this case, I do have money with the correspondent lending. And so I am actually making this loan. I'm later assigning it to Rocky, and Rocky's buying this loan from me. But that's the big difference there is I actually fund the escrow and fund the loan closing, and then you're purchasing the loan from me after the fact. So that's the major difference there is the funding source and where the money to close the loan is coming from.
So the originator on a deal that's a correspondent arrangement, they need to be licensed as a lender versus a broker, right?
Exactly.
No. So if there's a wholesale capital source out there that says, "Hey, we offer a correspondent lending program," that means both of them have to be licensed as a lender if they're lending in a state that requires licensing.
Most likely, yes.
Okay. And when people fund loans in a correspondent uh, situation, do they typically just have a balance sheet where they have the money to fund it and then they sell it shortly after? Do they use warehouse lines? How does that work?
Yeah, absolutely. I mean, any and all of those options. Usually, if you're going to be doing this sort of correspondent lending or, working with correspondent lenders, you'll be able to maintain your balance sheet for a while. So it's not like, I'm making 3 loans and I'm like, oh gosh, please, Rocky, buy one ASAP because I got to fund this other one tomorrow. That's not a good business practice. But usually what's happening is I have the ability to make these loans myself, but then I want to deploy capital again because, I can make those origination fees. Maybe I'm collecting an interest spread, something like that. And I want to work that game, but then you're more interested in, have servicing the loan for its life and getting interest in that whole thing. So it could be, that maybe some of them I even keep on my books, might sell to you as a third party shortly thereafter. Maybe I do have a warehouse line that I can utilize to fund these loans initially. And then as I'm selling them off to you, pay down my warehouse line. So there could be, many different options there. As far as, for that originator, how they're funding the transactions.
So as far as I know, correspondent lending is very common in the consumer mortgage space, but in private lending, where I've typically seen it or heard about it, is there's a large institutional lender out there that says, "Hey, we offer a correspondent program," and they say, "Hey, we'll offer you this warehouse line or a credit line," but I've never quite understood how that worked. And obviously I can ask one of the lenders for the specifics on how they structure it or arrange it. But as far as how does that typically work within private lending with these larger national firms offering a correspondent program to a smaller lender or a broker?
Absolutely. I think a lot of that will be, we've often talked about this agreement between the originator and the lender and what that means. In this case, it's going to be even more in depth because it's not going to just talk about, hey, you're bringing me deals that I'm funding. In this case, I'm really selling loans to you. And so now what does that look like? Is there like a seasoning period where these loans have to, not be in default right away? What are the terms of these loans that you accept as the purchaser? Do you not accept prepayment penalties? Do you always want to see one? Are there interest rates that you don't offer or interest programs that you don't offer? Is there collateral types that you don't like? There's like a whole list of things where you can say, here's the box of loans and the terms for loans that I would be happy to purchase, Melissa, so long as you're originating those and you can show, on a loan tape that, these loans meet these characteristics, I'd be happy to buy them from you. And then, there might be repurchase rules and that sort of thing if the loans are in default or are not as I've represented to you. But so that agreement tends to be very, very complex versus the other originator agreements are more so talking about fees and representation and that sort of thing.
And how about loan docs? Does that work similar to table funding, where the loan buyer is sort of predetermined, or is there extra work that needs to be done when the loan's assigned?
That's another great question. I know that a lot of correspondent lenders will want to see a certain set of loan documents in there. That said, I know that, and the reason for that is because it makes it very easy for them to purchase the loans. Because if I can show you our loan documents and you like our loan documents and you know to look in these 3 sections for the things that you care about to verify that it's a type of loan that you want, that's easy. Versus if it's, some random set of loan documents out there, that becomes hard because now you have to read them all. Not that you shouldn't every time, but now you really have to dig in and make sure that the documents say what they need to say, that you have reps and warranties in there, that all of the terms are correct, and it makes it difficult. So oftentimes in that agreement with the correspondent lender, it'll talk about accepted loan documents that the originators can use.
And the correspondent lender or the capital source, do they need to be licensed, if applicable, in that state?
Yeah, if applicable, some states will require somebody who's purchasing a loan to be licensed. So if that's the case, then you would need to make sure that you are licensed. And then similarly, on my end as the originator, there might be states that say you have to be licensed to sell a loan. And so that might be a separate license or different from the lending license potentially. So another thing to look out for.
But loan buying, it seems like it's an activity that's not, um, where a license wouldn't be required for it. It's really an investment. Are there any states that stand out where this is a requirement that you need a license just to acquire a loan or a note?
I can't think of off the top of my head. I know there are a few. It's very rare, but there are a few that are out there. So it's just something that I would check in before you start doing that.
Okay, but most of the country, it's not really an issue.
Exactly.
Yeah. Okay. Great. And how about legal liability? If someone's putting themselves out there as a lender, they've got the balance sheet or the warehouse line to fund that loan, but they're assigning it. Is it similar in terms of table funding and in terms of the liability that the originator might hold?
I would say there's probably slightly more liability in this situation because at the end of the day, you're most likely as the originator holding on to the paper for longer, than a day or a couple of hours, like you would in the other situation. So in this case, I would say, if say, for example, there's a seasoning period and, before I sell the loan to you, I have to show that there's 2 months of timely payments by the borrower. For those 2 months, if I fail to service those loans properly, or, like if there's things that I do during that time frame that, put this loan at risk, there's liability that pop up there. So hopefully, those agreements that you have in place with the warehouse lenders will go over those circumstances so that originator knows exactly what they need to worry about as they're selling these loans.
It seems like with these different capital structures, or of wholesaling or brokering, the economics must get better as you go up in level, right? Like when you start at a wholesale, you're just getting preferred pricing, and then you go into table funding, you have to deal with a lot more legal stuff and potential liability. Then you go to correspondent lending, and it's way more liability and way more expense.
Mm-hmm.
So there must be more profit in these different deals as you go up the food chain, right?
I would think so. I mean, I never see this side, or I mean, I might put like fees on a closing statement, but it's very rare that I'm like in on the economics of the deal. But I will say, I think even though it might seem that like, okay, if I'm just, wholesaling or whatever, like maybe I can, collect a big broker fee, or if I'm that lender, I can collect all of the interest rate or whatever it is. But I will say, like, as you go up, like, yes, the liability is more, but then, for example, with this correspondent lending program or whatnot, I have the ability to redeploy capital over and over again as I'm selling these loans to you. And so maybe there is a gain to be made there on, the origination fees, or maybe there's a yield spread in place or something like that, where it is more economical. I don't know though. So I really have no idea. That's the side where, yeah, I don't know.
No problem. And then tell us a little bit about Fortra Law and your role in helping brokers and capital providers or lenders with these different types of wholesale structures.
Absolutely. I think the biggest thing, I alluded to it at the beginning, but it's always jumping on a call and figure out what people mean by the terms they're using. People like to throw around phrases, and sometimes, you might be meaning that to say one thing, and I'm understanding it to be something completely different. It's kind of a funny joke, but even in our office, on my team, borrowers are borrowers, but sometimes on our corporate and securities team, Kevin calls them investors, but to me, an investor is a lender. And so, like, even that sort of thing, you really have to dig in and be like, what do you mean by that word? What is the actual activity you're trying to do? So, oftentimes when I'm talking to people, I'm figuring out what they're trying to do. It's not because I haven't heard of it before or I need you to educate me. It's because I'm trying to understand what your goals are, because then I can answer these questions correctly. I can understand, do you need a license? Is there another agreement that has to be in place? Is that activity prohibited in the state you're trying to do? So really digging in on that. And I think at the end of the day, that's the big service that Fortra provides, is that we are experts in this space as far as helping you get the deal done. We're not out here, deal killers. We're not trying to crush your dreams. If you're coming to us with questions and we're giving you an answer, we're trying our best to figure out how to make it so that you can do that deal. And it might require some restructuring depending on the laws of that state. So I would say that's probably the biggest area where we can help. And of course, we draft documents and all of that. But I would say most of the time that my team and I spend with our clients is on the structuring and figuring out their business and, these big picture strategies.
And as far as the docs, does any investor or lender that's table funding or offering correspondent lending, when they need loan docs, is it typically they just need it set up for one time, and then it's the same for all the transactions in the future?
So usually what we can do, I mean, oftentimes, like, like I said, like some of those bigger institutions, like they want to see certain provisions, but the thing is every loan is different. So I hate the idea of getting templates out there, because things are always changing, and maybe that provision was worked well in these set of documents, but when you take that out, maybe that actually changes and you needed to add something else when you did that. And so I really don't like templates for that purpose. The other thing that I'll say too is, laws are changing all of the time. And here at Fortra, we have a crazy research process and outside counsel, process where we're always going through looking at new laws, getting our documents updated, making sure they're compliant. And so it's something where, that doc set, works today, and that's how you record a deed of trust today. But, tomorrow they could pass a law that says now you need 3-inch margins on the first page or something like that. And so while that document could record yesterday, it won't today. And so that's another reason why I'm pretty against templates. I don't see them getting updated in the way that they should. And I think that can ultimately cause some more problems.
Well, let's say there's a situation where the originator is offering table funding to a capital provider, investor, a lender, and they have their own set of loan docs, but then the person actually funding the loan, the capital source, they need to review those docs and make sure it meets their criteria or guidelines.
Right.
Is there anything? Is that a common scenario that you typically review the originator's docs compared to what the needs of the capital source is, and then make adjustments to the whole doc set?
We can. I will say though, that is much more costly than if we were to prepare them ourselves. We can, but there's just like a time value there of, again, for me to read through an entire set of documents, make changes and updates and that whole thing, like that's going to take far more time than for me to draft a set of documents based on a template that I know and I'm familiar with and know where changes need to be. So we can, and we have, but it's definitely probably not the most cost effective way.
Sure. Makes sense. All right. Well, thanks for all that information. Was there anything else that I missed? Anything else you wanted to add?
I don't think so. This is a great topic, a complicated one, but one I'm glad to hopefully get some clarity to the industry on.
Absolutely, me too. That's why we're doing this. so, so thanks for all your insights. Thanks for your time, and look forward to seeing you at the next conference.
Can't wait. Thank you so much, Rocky.
And that's a wrap for this episode of Private Lending Insights. Follow Melissa Martorella on LinkedIn. Her and her partners at Fortra Law will periodically host webinars, they write articles, and put out a lot of great content focused on private lending. Fortra Law is listed in the services directory of privatelenderlink.com. I'll put a link to that in the description. Reach out to them to learn more about their services, and please mention that you heard about them from LenderLink and the Private Lending Insights podcast. Thanks for tuning in and listening all the way to the end.